printed.
So moved. Second.
Motion's been made by Tim and seconded by Dennis. All those in favor say aye.
Aye.
Opposed, motion is carried. Minutes were sent out in the same packet. Look for a motion to approve.
Approve the minutes from April 15th. Second.
Motion's been made to approve the minutes as printed. All those in favor say aye.
Aye.
Opposed, motion is carried. Thank you. Okay, now look for a motion to open the public hearing.
Make a motion to open. Second.
Motion's been made and seconded to open the public hearing. All those in favor say aye.
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 Opposed? Hearing is open. Take it away, Matt.
Thank you, Mr. Chair. So, the applicant is seeking approval of a variance to the property line setback shared with parcel ID 23.011.4801 on parcel ID 23.011.4800 and part of the east half of the southeast quarter, section 11, Township 140 North, Range 48 West, Oakport Township. So location of this is just straight north of Dilworth, and east a little bit of County 9. The zoning on the property is agricultural general. There's some floodplain fringe zoning to the east. They're both residential and agricultural. They have residents on each parcel and multiple ag outbuildings. So the applicant, Ryan Zimmerman, would like to construct an approximately 27,000 square foot ag office shop and storage building. Most of that would be on this parcel here, the big, larger parcel. There will likely be some encroachment though into the smaller parcel. Both properties are owned by Jerry Zimmerman. I think he's here with us this evening. They can't be combined per code because they each have a residence on them. The applicant's practical difficulty that he gave is he'd like to be comply with that 125-foot road centerline setback. So really looking for a variance to the side yard setback, which is 10 feet for accessory structures and 15 feet for principal structures. This could potentially be resolved with a boundary line adjustment where you would simply take this property line, and it doesn't show up as well as I would have hoped on the screen, but they follow that dash line and just essentially bump out this property line here. Could potentially do that. Other outbuildings, though, could be impacted by that as well. If this was to straddle this property line, I did check with the assessor on any assessment or valuation property tax implications, and she said there wouldn't be any. From our comprehensive plan, the most, I guess, applicable goal and objective to this request would be to maintain and operate an accessible, safe, and efficient transportation system for the movement of people, goods in the county. And that's one of the main reasons why we have these road setbacks. So ultimately, here you would need to determine whether the applicant has a practical difficulty that meets that three-factor test that's found in statute, that the property owner proposes to use the property in a reasonable manner, not permitted by official control, the plight of the landowner is due to circumstances unique to the property, not created by the landowner, and the variance, if granted, will not alter the essential character of the locality. Any questions for me at all? If you're, yeah.
I got one. We were just talking about the setbacks. Is the only county got the 125? Because that's Township Road right there.
Yep, and that would count for the
Would
county.
that be?
'Cause it's not in it.
90.
It's 125 feet.
Is it? Okay.
Yep.
Okay.
Yep.
Go ahead.
Any other questions for me at all?
Okay, would the applicant care to speak? Okay, is there anybody online or in the audience that wishes to speak for or against? Is there anyone in the audience that or online that wishes to speak for or against? Is there anyone in the audience or online that wishes to speak for or against? No more questions for Matt?
Nope.
Okay, hearing no questions, look for a motion to close the public hearing. Motion by Tim,
I'll second.
second by Travis. All those in favor say aye.
Aye.
Opposed? Public hearing is closed.
So, Mr. Chair, just a quick reminder that since the Board of Commissioners did adopt our new Clay County Land Development and Subdivision Ordinance on June 3rd, our findings have changed a little bit in that they've gotten a little more succinct. So, just a note there. They're largely the same, just some questions have been basically, or some of the findings have been consolidated. And again, I still did draft findings for this request they're your findings. You're free to change as you see fit or keep the same.
Okay, we will now go through the findings of fact. Is the granting of this variance in harmony with the general purposes and intent of the Clay County Land Development Code?
Yes.
I have yeses. Is the requested variance consistent with the Clay County Comprehensive Land Use?
Yes.
Does the applicant establish that there are practical difficulties in complying with the strict letter of the Clay County Land Development Code by demonstrating that the applicant, do I need to go through those?
I would go through those, just A through C, yep.
The applicant proposes to use the property in a reasonable manner not permitted by an official control. Exceptional or extraordinary circumstances apply to the property that do not apply generally to other properties in the same district or vicinity, and which result from lot size, shape, topography, or any other circumstances over which a landowner has no control or influence. And granting the variance will not alter the essential character of the property's locality.
Yes.
I would definitely agree. Would the literal interpretation of the provisions of the Clay County Land Development Code deprive the applicant of rights commonly enjoyed by other properties in the same district under the terms of this ordinance?
Yes.
Is the variance being granted the minimum variance that would alleviate the practical difficulty?
Yes.
The variance is limited to the setback along the common property line and does not affect other setback requirements. It allows functional site use. Oh, sorry. Does the variance request meet all below criteria? No variance shall be granted where any of the following conditions are not met. Adequate sewage systems or water supply capabilities can be provided.
Yes.
Part of the building is likely to become a temporary agricultural housing in the future. An interim use permit is required for that. Septic and water supply capabilities can be assessed at the time because they'll need to come back in for another hearing. So B, the plight of the landowner or hardship is not due to circumstances created by the landowner.
Yes.
The dual residential parcel configuration was not created by the applicant and cannot be resolved through parcel combination due to zoning limitations. say that the answer is yes there also.
Yeah.
Pardon? The variance, the variance would not allow a use that is not already allowed in the zoning district.
Yes.
Okay, yep, I did. There would not be significant adverse effect on public health or safety. Okay. Staff has proposed 2 conditions. We can add, subtract, leave the same as you choose. Conditions may be imposed in the granting of a variance. The condition must be directly related to and must bear a rough proportionality to the impact created by the variance. Condition number 1 is that the property line must be located by a licensed land surveyor. And condition 2 is that an encroachment easement describing the degree of encroachment be recorded against both properties as legally described. I've got in my notes that makes a lot of sense, because who knows what will happen 20 years down the road, and if there's a good description and a legal easement.
Yeah, Mr. Chair, I think the only rationale for including that condition was to just, so you could
100%
get
identify.
the degree of how many feet into the other property the building is encroaching, so that's known with certainty. That was the only reasoning for adding that condition, and not necessarily even a survey, just locating that property line.
And I would like to keep it there, because I'm in a situation now where the property that my wife and I own, it was all done by legal description. There isn't a,
No feet or, yeah. Well, I saw the conditions, obviously, we're reading through the findings of facts. I think both of the findings are warranted in this case.
okay? So look for a motion to approve, disapprove, or amend.
I'll make a motion to approve.
Okay, motion by Travis. Second by Dennis to approve the variance with conditions 1 and 2. All those in favor say aye.
Aye.
Opposed? Motion is carried, variance is approved. Okay, now back. Okay, any unfinished business, Mr. Matt?
No unfinished business.
How about new business?
No new business unless anyone wants to take a spin through the new code. Otherwise, I'm going to plan on sending it to you all and just highlighting the, primarily the board.
Shortened up a bit.
What's that?
I said I got shortened up quite a bit.
The findings? Yes. Yep. Yep. And then the code itself, I think, is a little longer. It's about 208 pages. So I think before it was like 170 something, but yeah, in accordance with statute, essentially, that practical difficulty for variances is that those 3 factors essentially is the kind of the heart of that. So just making it more focused on that, I think, was key, as opposed to adding a lot of additional criteria that may not be necessary when considering a variance.
Okay, apparently nobody wants to talk about the twins, so,
We haven't went over a whole lot on the flood hazard zones. You know, we haven't had too many meetings on that. Could we go through that?
One thing I could do is I could reach out to, I could put something together for our next meeting, or I could reach out to the DNR, and they're always happy to come. They have their floodplain manager who is very good at outreach and would be willing to give kind of an overview of that. With regards to findings, there are two kind of attachments to these findings, and they only really come into play if the property is in a shoreland district or if it's in a flood, what's called a special flood hazard area or flood hazard zone. For shoreland, really, just looking at checking that there's a conforming sewage treatment system present, and that's in Minnesota Rules 7080, I believe, is the septic. For flood hazard zones, if the property is in a flood hazard zone, there's a number of questions or findings that would need to be made positive. You'd have to make positive findings for these. So we don't want to grant variances that would result in a lower degree of flood protection than what the regulatory flood protection elevation is. So that's what you could legally build at, and that varies from property to property. There are different types of flood protection that you can do that would be below that, essentially. Making sure that any variance wouldn't increase flood levels elsewhere. And then you have to meet these kind of three criteria here. If there's a good sufficient cause in granting the variance, failure would result in hardship, wouldn't result in increased flood heights, thrust to public safety, extraordinary public expense, nuisances, fraud, or victimization of the public, or conflict with existing local laws and ordinances. And then does it grant the minimum necessary deviation from the considering the flood hazard to afford relief? So you can see there's some similarities here between our findings that we do for every single variance, asking if there is exceptional hardship, if it's the minimum variance necessary to grant relief. And really what these come from are essentially FEMA, so our just the federal flood regulations and then the state flood regulations as well.
And these are likely to change some when the diversion is completed?
So these findings won't necessarily change unless there's changes to state statute or state rule or the federal code. Then there could be potentially some changes. With the diversion, though, there will definitely be changes to the floodplain in areas that are in the floodplain currently. So I've looked at, for example, in the past couple of weeks, 2 properties that are currently in the floodplain. Once the diversion is complete, they will not be in the floodplain anymore.
It's a long process, though, to get that stuff lifted.
Yep, I think it's anticipated to be complete in 2027. Then you still have to get all the levees certified by FEMA, and that usually can take a year. So should be operational if everything goes according to plan by 2028, 2029. Yep, but that will, yep, so.
Did anything for, I gotta think about this, the setback for building next to water, like some of the ones we've done for Lee Lake, did that change?
The setbacks, yes, they did change. Yep. So typically, just in general, typically we used to have like a 200-foot setback. Now it's 150 for most bodies of water in Clay County. Turtle Lake obviously is a little different because it's a different type of lake. Yep. Yep. So,
Yeah, we attempted to line that up with the state, so the state and the county were,
In unison.
yep,
Becker County can be different if they want, because, you know, they're Becker County.
so,
I just
Yeah.
know, you talked about that might change, so.
yep, that did change. Any other questions? The code too is,
On the county website.
yep. And it's currently, living in our planning and zoning page here. But eventually, where it will go is, we're working on now is getting it over into this county code. And the county code is here. And so the county code is, all the laws of the county. And so we have Title 1 through 7 right now, and this will eventually be Title 8. So you'll be able to just find it here. It'll be all online. It won't be like a separate document that opens up. You certainly can get that if you want. You'll be able to search it, so it should be easier to find things. So they're going through that process now of, it's called codification.
Okay, hearing no further discussion, look for a motion to adjourn. Motion by Tim,
I'll second.
second by Travis. All those in favor say aye.
Aye.
Motion is carried, meeting is adjourned.